This is Bloomberg Law with June Grasso from Bloomberg Radio.
Recent Supreme Court terms have been dominated by blockbuster case after blockbuster case. In recent years, the court eliminated the constitutional right to abortion, effectively ended the use of race as a factor in college admission decisions, and expanded gun rights. It also curtailed the power of federal regulators, threw out a federal ban on bump stocks, and granted Donald Trump broad immunity from criminal prosecution. So far, this term appears to be quieter. The highest profile cases argued involved challenges to federal regulations for ghost guns and access to gender-affirming care for transgender minors. We're going to take a look at the arguments coming up at the Supreme Court in the new year. Joining me is constitutional law expert Harold Krent, a professor at the Chicago-Kent College of Law. Let's start with the three First Amendment cases. The case over the TikTok ban, the case challenging a Texas law that requires porn sites to verify the ages of users, and an attempt by a charitable arm of the Catholic Church for an exemption from Wisconsin's unemployment tax. So the first arguments of the year are the arguments over TikTok's ban next Friday, which is a special argument day set aside by the court. Tell us about the First Amendment argument in this case.
Well, Congress in early 2024 passed a law requiring TikTok basically to be divested from its Chinese parent ByteDance by January 19th, 2025. So that date is rapidly approaching, and the divestiture requirement has been challenged under the First Amendment, and it's far from frivolous. And so the court did decide to take an emergency appeal. So it's not exactly on the merits. It would be an emergency appeal about whether or not they're so convinced that the First Amendment issues are substantial enough that they would give an injunction against the statute to get rid of the January 19th deadline. So obviously, TikTok is incredibly popular in the United States, particularly amongst young people, but also for adults as well. And the fear that led Congress to order the divestiture is the fact that there is not only a Chinese parent, but the Chinese parent here can collect so much information, about 100 million users or so on TikTok, and then change the algorithms by which people see information, and through doing that, influence America in a way that is more pro-Chinese. There's been no evidence that ByteDance and TikTok has done this, but it's certainly, I think, well accepted that they could, if they wanted to, sort of just disinformation all the incredible number of users of TikTok in a way that would jeopardize our foreign policy. So that's what led Congress to order the divestiture. But that raises huge First Amendment questions because it is picking out one particular social media platform and saying that there can no longer be free expression in that venue because of the fear of the Chinese influence. So it really raises a very important but a very novel First Amendment claim, and that's what will be heard January 10th in order to make sure there's enough time for the court to act before January 19th if they are so inclined.
So one thing that's interesting is that President-elect Donald Trump asked the court to stay the law without taking a stance on whether the law is unconstitutional. And here is what his lawyer, John Sauer, the future U.S. Solicitor General, wrote. President Trump alone possesses the consummate deal-making expertise, the electoral mandate, and the political will to negotiate a resolution to save the platform while addressing the national security concerns expressed by the government. It's unprecedented to have a future president intervene in a case before the court, before he takes office, to try to counteract something that the current president has done.
So what's even more amazing about that filing is that it raises a presidential power issue under Article 2 that has never been discussed in the court before, which is what about the Article 2 interests of a president-elect? Because what President Trump has done in a kind of rambling filing is suggest that his prerogatives as a future president should be preserved under Article 2 by deciding to stay the divestiture date of January 19th. We've just never had a case on the powers of a president-elect, and President Trump's filing does raise the issue. It's a can of worms that has not been opened, but it may be opened by the Supreme Court. We'll have to see. Of course, the court doesn't have to reach that issue in deciding whether to stay the case or not, but it's a fascinating sub-issue.
Well, we were all surprised when the court expanded presidential immunity from criminal prosecution. So I suppose anything is possible?
Anything is possible. And, as a political matter, President Trump's submission makes some sense because what the court does by delaying or not delaying the deadline on January 19th will have an impact on his presidency. And so there is absolutely more than a kernel of truth in what President Trump has stated.
And we're guaranteed to get a ruling quickly in 1 week's time because the court has to rule before that January 19th deadline.
And there will be a number of options. TikTok, of course, can sell itself to an American company, and there are some American-based companies that are suggesting that they're interested. So there are ways that TikTok can continue on even with this deadline looming.
So on January 15th, the justices are going to hear arguments in a case challenging a Texas law that requires porn sites to verify the ages of users. This has forced one of the biggest sites, Pornhub, to shut down in Texas. Industry groups are fighting this, are suing over this. What is their contention?
They have two general First Amendment claims, and I think they're quite substantial. The first is more of a doctrinal one. The court below used a kind of rational basis test in order to assess the legitimacy of this statute in terms of protecting minors as opposed to a more demanding scrutiny test. And if their strict scrutiny had been afforded, as it has been afforded to other similar kinds of age restrictions in statutes on First Amendment grounds, that then the statute probably would be struck down. So the first challenge is simply one, did the court below use the wrong standard of scrutiny, in which case the court might then just remand it back for another go-round with the Fifth Circuit. But the second issue is more predictable, which is if you have a age verification on a statute and you require adults to put in, whether it's driver's licenses or other proof of age, you will deter people from going to that site for fear of privacy invasions, for fear of manipulation, etc. So there will be a diminution in free expression by having an age verification on this kind of site. So that's sort of one traditional First Amendment argument. And, the second is probably the way the statute is crafted, it applies to any site which has at least a third of its material which may be distasteful or have sexual content which is inappropriate for children. Well, how do you determine that if you have artworks on display or if you have some kind of erotic poetry? And so there may be just a deterrence of speech by websites having to self-edit for fear of reaching this 1/3 threshold, which is very hard to ascertain. So there is a Supreme Court case almost on point of about 20 years ago that looked at the Child Online Privacy Act, and it had an age verification in it, and it was struck down as unconstitutional and never reenacted by Congress. And I would predict that the Texas statute would be held to be unconstitutional as well, particularly if the heightened standard of scrutiny is required by the court.
The Texas Attorney General is pointing to a 1968 Supreme Court decision that said states could bar the dissemination of pornographic magazines to minors. Is that compelling?
Well, the difference is the websites, right? Once we have a whole kind of different world that can't be cordoned off into magazines delivered or magazines not delivered, we have a new First Amendment dimension that has been added to it. Now, what's interesting, I think, about this is that the Biden administration has held that it's likely to be unconstitutional. And so the question is, what will the Trump administration do? And that's something that's common in all of these cases is when there has been not so much in the Texas case, which will go on because it doesn't involve an act of Congress, but once there has been a determination by the Solicitor General of what position to take, the Trump administration may file something and say, we no longer have that position, or we're changing that position, we're changing a regulation. So a lot of the cases that are on the docket for this first half of 2025 may end up in a very different procedural stance than when it started.
So the justices are going to review a Wisconsin Supreme Court decision that denied Catholic charities an exemption from Wisconsin's unemployment tax.
The question here is whether you can deny a tax exemption to an arm of a religious institution, even though you couldn't deny it to the religious institution itself. So the states that have these exemptions in terms of applying it to religious organizations, they say religious organizations are exempt, but how do you tell if it's really a religious organization? And the language in the Wisconsin statute itself basically held that it has to be organizations that are operated primarily for religious purposes, and they use a test to determine not just the motivation underlying the arm of the religious entity, but also their activities. So in this case, they said, yes, there can be great religious motivations for operating charities, and they lauded the efforts of the Catholic Church to help out people with disabilities. But they said that the actions of the religious group are secular. It's nothing about imbuing people with religious sense or devotion or anything along those lines. And the court therefore made a distinction between a motivation to create a school, for instance, or a hospital, as opposed to trying to encourage religious doctrine. So that is a difficult line drawing issue, and that's the argument here of why it's unconstitutional that it'll enmesh the courts in determining whether these activities are really religious or not. But on the other hand, as the Supreme Court said more than 20 years ago in the Waltz case, sometimes this line drawing for tax exemption is just inevitable. You can't really get around it. You have to have some kind of test in this instance to try to suggest that when you can have exemptions from, in this case, taxes that help people who are unemployed, citizens of Wisconsin, on the one hand, on the other hand, be respectful of religious institutions. So that's where the test of motivations and activities separations come from. And we'll see if the court can stomach that. It's really unclear.
So, but the Roberts Court has expanded religious rights over and over again. Is this another chance for them to expand religious rights?
It is a chance, and it wouldn't be shocking for the court to do that. But it is, I think, only fair to note that if the court decides that Wisconsin cannot make a distinction between Catholic charities and the Catholic Church, that this will give a huge advantage to religious-based organizations that are in healthcare and education, who then don't have to pay the same taxes that secular hospitals and secular universities would.
Coming up next, will the powers of federal agencies take another hit this term? This is Bloomberg. I've been talking to Professor Harold Krent of the Chicago-Kent College of Law about the oral arguments coming up at the Supreme Court in the new year. So let's turn now to some cases involving agency authority, which the Supreme Court has been rigorously, shall we say, cutting back on federal regulatory authority. They're going to consider the constitutionality of the $8 billion annual subsidies that help cover the cost of telecom services for poor people and rural residents. So this is about the power of the Federal Communications Commission.
Absolutely. This is a Federal Communications Commission rule, but it's done by delegation from Congress. And so Congress has delegated to the FCC the power to impose this fee. And the first claim against it is the fact that the FCC shouldn't be imposing a fee. That's a tax, and only Congress can impose taxes. This would be a wild argument if the Supreme Court buys it, because agencies apply user fees all the time. And you can look at user fees as a tax. You can look at them as something else, a subsidy. How do you distinguish one from the other? So one way that the court could just cut back, again, dramatically, the power of agencies is to begin to say that anything that looks like a tax can only come from Congress as opposed to the agencies. I don't think the court will go there, but that's at least one possibility. And there's another one that is pretty clear, because the statute itself says that the fee should be, quote, sufficient to preserve and advance universal service. That admittedly is quite vague. And so this is another vehicle potentially for the court to revive the non-delegation doctrine, and that would say that Congress, if it gives power to the FCC, has to be far more nuanced and clear than this sort of broad understanding that they set fees sufficient to preserve and advance universal service. It's just not giving enough direction to the administrative agency. And there's a third side of this particular challenge, which I think is going to be very close on the Supreme Court, which is that the agency has given too much power to a private group. The FCC decided to use a group in this case, which is called the Universal Service Administration Company, which is a private group of mainly people in the telecom industry. They gave them that power to set the fee, and provided that if the agency took no action within 14 days, the fee recommended by this private group would become binding. So the court may say that the involvement in this private group makes the delegation even more constitutionally problematic and strike down the structure on that ground. And I think maybe it's a small point, but I think the court might say, look, the agency at least has to take some positive, concrete action, such as accepting a private recommendation from the group as to the fee before it becomes binding in the name of the United States. And as the statute is, written, the private group's recommendation becomes final if no action is taken on behalf of the agency. And that might seem like a minor issue, but it may be just one step too far for the court in order to signal to Congress to stop giving too much authority to private parties who are not subject to close oversight by the president or heads of agencies.
You mentioned wild arguments. This case is an appeal from the Fifth Circuit, which is the most conservative circuit in the country and often has novel arguments, shall we say, and it's a split with two other appellate courts in declaring the program invalid. So does it seem like the court took this case to reverse the Fifth Circuit?
It's unclear to me. I think that the case has some merit to it. And I think that the court has been interested in non-delegation issues, and particularly non-delegation issues involving power that's shared with private parties. So I'm not surprised that the court took this case, and there is a split in the circuits, and I don't think we can be confident that the court's going to rebuff the Fifth Circuit in this particular case. I think they will in other cases, but not necessarily in this one, because this is somewhat of a standardless delegation involving sharing power with private parties, something that is of interest to a number of the justices.
There is a clash involving California's strict vehicle pollution laws. But this is a preliminary question of standing and whether the fuel producers have the legal right to sue over the regulation.
That's right. I mean, the underlying this case is a waiver that is very controversial that the EPA, or Environmental Protection Agency, gave to California to exempt them from sort of national requirements in terms of regulation of fuel emissions, allowing California to go its own way. California has gone its own way since 2013. It was cut back a little bit during the Trump administration, the first one, but not completely. And California is much more rigorous in terms of requiring less fuel emissions than other states. And of course, the industry has chafed against that repeatedly, but lost it politically to try to do anything about it. So this involves some lawsuits by fuel producers saying because of California's exemption, their ability then to regulate more stringently, people are buying less fuel. And at the one level, you can say, yes, that's logical, and that these fuel producers should have standing because they're injured, because people will likely then pay less money for fuel if they have more energy sufficient cars. But there are two problems with the argument, and that's what led the Ninth Circuit to hold that there is no standing in this case. The first is that there is no showing that car manufacturers would make different fleets of cars available but for California's rules. And so the argument there that was given by California is saying, if you think about Tesla, if you think about even, Chevrolet and Honda and so forth, they're making more fuel-conscious cars all the time, the electric fleets, the hybrids, and it's not clear that even if California changed its regulations, that they would decide to produce a different type of car for the market. Now, that's a serious argument, and it does undercut, I think, standing significantly. But then the court relied on a second reason to suggest there was no standing, namely no redressability, because the actual action that the fuel producers was challenging was the plan of California that was to be implemented from 2017 to 2025. Well, guess what? We're in 2025 now. So even if car manufacturers would produce different cars if California lessened its regulation, they couldn't do it in time for 2025 because there's too much lead time required to bring different cars to the market. So the argument is pretty strong that there is no redressability in this case, namely that even if the fuel producers won and would say that this waiver for California is against the spirit of the statute, that there still would be no change because there isn't time for a change, and that whether a change would happen is still so speculative because it depends upon the actions of third parties not before the court, namely the automobile manufacturers. So at the bottom of the case is a very important issue of power. And did the EPA violate somehow the statutory instructions by giving this broad waiver to California? That's a very important issue. But in this particular context, the court, I think, is probably on strong ground in saying no standing.
And California's waiver, isn't it in danger already because Trump campaigned on promises to end EV mandates, and his administration is expected to try to withdraw the waiver?
So it's an interesting question, right? Because at the one hand, during the first administration, there was a restriction of the waiver authority of the EPA, but it wasn't gutted completely. And Elon Musk, who is a friend of the president so far, as we know, certainly benefits from the tighter restrictions that are imposed by California. So what the Trump administration will do is really an unknown, but yes, it may change the face of this litigation substantially if the Trump EPA decides to pull back the waiver.
So the court's going to consider reviving a plan to store as much as 40,000 tons of highly radioactive waste at a temporary West Texas site. And Texas is opposing this. What is the basis for Texas's opposition?
So originally under the Atomic Energy Act, it was clear that the Nuclear Regulatory Commission had the power to license both radioactive dump sites that are located at the nuclear facility as well as radioactive storage sites off-site. And the Nuclear Regulatory Commission and its predecessor did this for generations. Congress, however, recognized that there was a great deal of difficulty and tried many times to encourage others to build these radioactive sites because nobody wants them. And so they wanted to create enough sort of incentive or force to make sure that these sites existed, which are critical because of the waste coming from nuclear facilities. And there's been a series of litigations that have been spawned by this effort. But the key issue here, according to the Fifth Circuit, is when Congress later enacted the Nuclear Waste Policy Act in 1982, it was clear in that act that it was encouraging the actual operators of the nuclear sites to create their own storage facilities. So the argument that was given by the state of Texas was that this particular license violates the spirit of the 1982 Act, which was subsequent to the original authorization for the regulation. And if Congress is saying we are encouraging all site owners to develop their own temporary storage facilities, how can the agency go and license a one that is off-site? This is the question about really interpreting the statute. Is it just a hortatory kind of statement from the Congress saying we think this would be a good idea? Or can this really be interpreted as the Fifth Circuit did to say you are no longer allowed to license any off-facility place? I think it's likely that the court is going to turn back the Fifth Circuit here because it would be such a reversal of practice over the last 25 years and more, but we'll have to see.
And again, this is the Fifth Circuit in conflict with other circuits, upending more than 40 years of NRC practices. So
I think that this is a long shot. There's also another procedural issue involved in here, which is the state of Texas was not involved directly in the licensing hearing at all. And jurisdictionally, under the jurisdictional provision, only those who were involved in this particular kind of rulemaking can challenge the licensing decision in court. And what the Fifth Circuit held here was, yes, Texas and others were just attempted interveners, and they were not parties to the case, but they noted an exception for parties who were challenging the administrative authority of the agency. So the Fifth Circuit used an anti-agency rationale to say that we ought to ignore the jurisdictional provisions set by Congress to invite more people in to challenge agency action if we think the agency action is outside of Congress's directions. And so this is, again, a clearly anti-administrative agency tenor to the decision. So it's possible the court could just say, you're wrong, Fifth Circuit, and the interveners cannot raise this challenge to the licensing provision and therefore get rid of the Fifth Circuit decision on that ground.
The court is also going to take up another redistricting issue, a new clash over the use of race in redistricting. This is arguments on a Louisiana congressional map that creates an additional majority black voting district. And this issue has come before the court before, but it's based more on facts than anything else.
Yeah, so in the cases before the court before, the court said, well, we're not going to get involved in it. The election in 2024 can continue with this new district intact. We're not going to say one way or the other whether it's a good idea or not. And the Louisiana legislature had approved the new districting in the wake of a determination under the Voting Rights Act that the prior allocation of boundaries or setting boundaries violated the principle of fairness in the Voting Rights Act itself. So Louisiana was trying to remedy a statutory violation in creating this act. Now, the act is a little controversial because it's clear that the Louisiana legislature discussed it making safe seats for people like Steve Scalise, the would-be Speaker of the House, and chose to redistrict in a way not only that ensured two districts were majority black, but also ensured that their favorite Republicans would stay in power. So the three-judge district court, after the Supreme Court decision, held that this was unconstitutional because the effort to redraw the map not only was race-based in terms of creating a second majority black district, but also was done not on neutral principles. So those issues are percolating here, and it's unclear what the court could do because the court could use this as a way of limiting remedies on their Voting Rights Act. They could knock out some of the Voting Rights Act itself, or they could have a very narrow decision. So this one's definitely worth watching.
So now there's also a case involving Title VII of the Civil Rights Act, and it involves pleading requirements.
Yeah, so in order to advance in a Title VII case or discrimination case, you have to show kind of a prima facie case that you were treated differently than another covered group, and that because you were treated differently, it resulted in some kind of adverse employment action. So to even get to the pleading stage, one has to allege these particular type of harms. And that's been consistent since Title VII was enacted in 1964. Now, what happens if you're a member of a majority religion or majority race, or if you're straight in terms of your sexuality, and if you then make a claim that even though you're straight, you were treated unfairly based on your straightness, and therefore you are claiming some kind of discrimination that's protected under the Act. And indeed, in the Ohio case, there was an individual who is straight, and she didn't get a promotion, and instead the promotion went to someone who was gay, and then was later demoted, and someone took her old position who was gay as well. And even though someone who was straight made these employment decisions, she claimed that the decision was in violation of her statutory rights to be treated the same as anybody else based upon her sexuality. And a number of courts have held, but others have disagreed, that there is an additional hurdle that somebody who is of a majority religion, race, or who are straight, as in this case, has to surmount before they can get into court, and they have to show background circumstances to give more sort of color or more oomph to their argument that they were treated unfairly based upon a covered characteristics. And in some ways, that requirement makes some sense because for a court, they have to go into any kind of analysis and waste resources to determine if someone who is of a majority race, religion, or sexual appearance, that just wastes time because it's so unlikely that if you're a majority, you'll be subject to discrimination. And so those courts said then, as a way to conserve resources, we just want to make sure that somebody who pleads the case will show a little bit more of those background circumstances, which suggests despite the fact that they're majority, they were subject to discrimination. And, in this case, the decisions were made by someone who was straight, just as was the plaintiff. But the Biden administration and a number of courts have said there's one standard under Title VII, and it applies to everybody the same, and so there is no basis for this sort of judicial common law making of adding this special pleading requirement of background circumstances. So it's going to be interesting to see what the Trump Solicitor General will say about this, and it's really unknowable what the court will say because I think, in my view, it is a rule of thumb. Yes, it should be harder to show discrimination if you're a member of the majority group, whether religion or race or sexual practice, but there is only one Title VII, and so maybe the court should just look at it more skeptically without having any kind of formal requirement of additional procedures.
In his annual report on the federal judiciary, Chief Justice John Roberts issued a defense of judicial independence, which he said is under threat from intimidation, disinformation, and the prospect of public officials defying court orders. With a string of alleged ethical missteps by justices and controversial decisions, including a landmark presidential immunity decision written by Roberts, Americans' confidence in the country's judicial system and courts has dropped to a record low of 35%, according to a Gallup poll. I've been talking to Professor Harold Krent of the Chicago-Kent College of Law. The chief's annual report typically ignores current concerns surrounding the justices and the institution. But his focus this year was on what he called illegitimate activity aimed at undermining the independence of the judiciary. He had 4 areas of concerns: violence directed at judges, efforts to intimidate them, disinformation, and government officials' threats to defy court judgments. What did you take from his end-of-year report?
You can be empathetic to his wish and his hope and his fervent desire that the Supreme Court retain its independence and respect in our society. And I guess on one hand, you could be skeptical, given that a lot of the loss of support and respect for the court has come because of this court's decisions. And as you mentioned before, most notably Chief Justice Roberts' decision in the presidential immunity case, but other decisions in the abortion case as well. But I think he is right that we are in this politicized world even more open to attacks upon judges than we were before. And there's been picketing in front of judges' houses, as we know, or justices' houses, and that's something to be, I think, probably a little bit frightened of. But there's also been other kinds of defiance. And, Vice President Vance has suggested that certain times it's totally appropriate for the administration to ignore what the Supreme Court would hold. So there are challenges coming from various different sectors, people that just disagree with the court, as well as with people think that they don't have to listen to what the court says. So there is reason for Chief Justice Roberts to decry those kinds of challenges to the court's authority. But I think at the same time, part of the problem is the court's own doing.
I think everyone agrees that the violence against judges should be stopped. But when he talked about intimidation and he mentioned protesters, quote, intent on harassing judges. And public officials, he said, have tried to intimidate judges by suggesting political bias is behind their decisions without a credible basis. Both of those seem like First Amendment protected activities to me.
They can be, right? It's a fine line to draw between when they are harassment as opposed to when it's just criticism of the court. And the way to, I think, see this clash most plainly is to talk about, and we'll look at the immunity decision. And some people can criticize it as being badly crafted. Others can say it's just illegitimate. And those are two ways of criticizing the opinion. And it's hard to say what is really the difference between saying it's poorly reasoned as opposed to it's politically lawless. Those are just different perspectives if people don't accept the opinion. And so I think he's conflating one with the other to some extent, but it is notoriously very difficult to try to figure out what is legitimate dissent, protest, as opposed to one which is saying that the Supreme Court is lawless and we should have a quick overhaul of the entire judicial system.
And you mentioned he took aim at threats to ignore federal court rulings by elected officials, which he said had come from across the political spectrum. But Vice President-elect J.D. Vance had said, and when the courts stop you, stand behind the country like Andrew Jackson did and say, the Chief Justice has made his ruling, now let him enforce it. I just want to mention that Vance's wife clerked for the Chief Justice.
Which is an odd turn for sure. And the Jackson issue arose, at least allegedly, out of protest from a Supreme Court decision saying that the removal of indigenous peoples from a particular reservation was illegal and, ordered the administration to comply with it. And by all historical measures, Andrew Jackson refused and continued to disband the indigenous communities. And, with the vice president articulating that kind of issue, it's putting into play this notion that the court is just another political arm of the country and that it should be subservient to the president and vice president who were elected and given a mandate by the voters, unlike the Supreme Court itself. And that is a dangerous notion, and maybe some progressives have flirted with it as well in frustration with what the court has done recently. But now the court is being challenged by members of its party who appointed most of them, which are the Republicans. So they have reason to be nervous because they're now potentially going to be challenged by both sides of the political spectrum.
Hal, thanks so much for spending so much time with me and taking us through what's coming up this year at the Supreme Court. That's Professor Harold Krent of the Chicago-Kent College of Law. Coming up next, we'll take a look at the status of Trump's New York cases. You're listening to Bloomberg. Turning to the civil and criminal cases against Donald Trump in New York, a federal appeals court has denied his request for a new trial in New York writer E. Jean Carroll's sexual abuse lawsuit, dealing a blow to the president-elect as he seeks to put his legal woes behind him before taking office. Joining me is Bloomberg legal reporter Erik Larson. Erik, the Second Circuit handed down this decision on Monday. Erik, the Second Circuit handed down this decision on Monday. Remind us what the trial was about.
So Trump was found liable by a Manhattan jury in May 2023 after a trial in E. Jean Carroll's lawsuit accusing him of sexually abusing her in the 1990s. And it also included a claim for defamation for some things that Trump said about her after he left office during his first administration. And the jury awarded $5 million in damages to E. Jean Carroll. Trump appealed, and the Second Circuit Federal Appeals Court in Manhattan rejected Trump's request for a new trial.
And what were Trump's arguments supporting his request for a new trial?
So Trump argued that the trial judge made evidentiary errors by allowing certain evidence and testimony into the trial. He argued that the testimony from two other women who had made allegations of sexual assault against him should not have been allowed. Two women took the stand and gave testimony about Trump allegedly assaulting them. And also the so-called Access Hollywood tape, that 2005 hot mic recording of Trump sort of bragging on the Access Hollywood bus about kissing and groping women without their consent if he finds them attractive, and being able to get away with it when you're a star, to use his words. So the jury heard that tape, and they also heard the evidence of these two other women, Jessica Leeds and Natasha Stoynoff, and were able to use that evidence to show a pattern of behavior that the jury agreed Trump had.
The testimony from the women, first of all, what did the appellate court say about admitting that testimony from two women not connected to the allegations in the case?
Right. So the appeals court decided that the judge did not make an error by allowing this testimony and this evidence in. It's a type of evidence that it can be limited and barred in some cases, particularly in criminal cases. If you have someone come in and testify about a defendant doing something that was alleged but never criminally proven, just to show a pattern of behavior, that kind of evidence is usually not allowed in if it's a criminal case, just because there's more at stake. Someone's freedom is at stake. And again, these are testimony about allegations that were never charged. These two other women did not make these allegations at the time. They never, sued him. He wasn't criminally charged, obviously, with that conduct. So he argued that it shouldn't have been allowed against him, that it, tainted the jury's perceptions of him when the allegations had never been made previously. But the court determined that because it was a civil case, and just because of the nature of what said by both women and what was said in the Access Hollywood tape, that it was fair for the jury to use that evidence to show, as they put it in the decision, a pattern of abrupt, non-consensual and physical advances on women he barely knew.
Has there been any talk about Trump appealing to the Supreme Court?
I would say that that's almost a certainty. He's pretty much appealed anytime he's gotten a ruling against him or lost in a case like this. He does appeal. So I think we can expect that petition to be filed.
He's separately appealing another verdict involving Carol that resulted in an $83.3 million verdict. Do we know what his appeal issues are there?
So that case is also in a case brought by E. Jean Carroll. The first one that we had just been discussing was filed under a New York state law that allowed women to file sex abuse civil claims over alleged attacks that had happened even decades ago. It was a temporary lifting of the statute of limitations. Their earlier case, the one that went to trial later, that was a pure defamation claim over comments that Trump made about E. Jean Carroll in 2019 when he was in the White House. That case was long delayed because of his immunity at the time while he was in office. But he, again, argues on details of the alleged defamation about him being protected by immunity while he was in the White House. Some of these statements were actually issued sort of through comments on official White House statements, and he argues that he's protected and that he is allowed to defend himself when, in this case, E. Jean Carroll had gone public with her claim that Trump had raped her in 1996 in the Bergdorf Goodman department store. He issued statements, and sometimes crude statements, denying the attack and making remarks such as that it was a fabrication, a hoax that she had created to help Democrats, and also at one point suggesting that she was not his type, therefore somehow not attractive enough for him to assault. At any rate, these are things that he says he's allowed to say in his defense after allegations were made against him in office.
And we're still waiting for Judge Juan Merchan to rule on the criminal case?
That's right. This is the big decision here that we've been waiting for, could come at any time. Of course, Trump was found guilty in that case. I think this is the one that everyone is just waiting to see whether or not the judge is going to allow this case to go away because Trump is going to take office, or put it on hold so that Trump can be sentenced after he leaves office, which would be a very obviously unprecedented, rare situation where the judge has to decide how far he's going to go, squaring off against Trump over this verdict. It's such an unusual situation because the verdict was handed down before the election, but then Trump was never sentenced, and then he won. So it's a tough spot for the judge to be in.
I would fall off my chair if the judge just throws out the case after a jury has rendered a verdict after a full trial.
It's pretty surprising. I mean, as the Manhattan District Attorney Ellen Bragg said in his brief, the jury has such an important role in our judicial system. They listened to all the evidence, heard the testimony, and made a very significant finding about Trump's conduct, and he was convicted. And so as we sit here today, he still faces potentially up to 4 years in prison if this case doesn't go away.
And we could hear the judge's decision any day. Thanks so much, Erik. That's Bloomberg legal reporter Erik Larson. And that's it for this edition of the Bloomberg Law Podcast. Remember, you can always get the latest legal news by subscribing and listening to the show on Apple Podcasts, Spotify, and at Bloomberg.com/podcast/law. I'm June Grasso, and this is Bloomberg.